So I want you to listen to this audio, and I want you to see what I deal with on a regular basis, week in, week out. When I help clients, every time I go into a court, I know where their weak points are. And I expect them to violate the ADA. And I point it out to them, and they have no clue. This court in Massachusetts sent me through 3 different people. I'm pretty sure the last one was an esquire, was a lawyer. And they still did not know their ass from a hole in the ground concerning the ADA. So listen to this. I know there's a lot of people that hate it when I interject in videos, and so I'm going to let this one run. I put some notes in along the way, and I'm sorry in advance for the noise that's on this. Evidently, I had my recorder too close to my computer, and it caused some interference, but you can get the gist. And if you'll listen to all of this, I think you'll see what I deal with on a week in, week out basis. And this is why we need more ADA advocates, period. We need a lot more.
County Probate and Family Division, located at the Edward W. Brooke Courthouse, 24 New Chardon Street, Boston, Massachusetts.
Suffolk Probate and Family Court.
Yes, Tanya Brusa-Pagan, please.
I don't believe she's in or today.
Okay, this is Jay Shore. I'm calling on a recorded line, and I am a certified Americans with Disabilities Act advocate. I have communication disability, and I'm supposed to be aiding and encouraging Miss in a matter that she has this morning, and I asked for accommodation, and so has Miss through communication to Miss Brusa-Pagan, and I have not received any response to this and no access. So what should we do?
Sorry, could you just repeat that last part in here? I heard you're advocating for accommodations. Mm-hmm.
And we need accommodations. Can I forward the accommodations to you? It's a written letter.
And you said you were with which association? Sorry.
I'm a certified Americans with Disabilities Act advocate. I'm not with an organization. I'm a private advocate. But the thing is, I'm under 42 U.S. Code 12203. Anyone can aid and encourage another in the exercise and enjoyment of their rights, and that's what I'm doing. And I do this with court. My certification is actually for litigants with invisible disabilities.
If you don't mind a brief hold, I could transfer you to someone. That might also be of help.
Okay.
I just know that Tanya's not in right now.
Okay.
One moment, please. Hello?
Hello.
So what sort of accommodations are you seeking?
They're in writing. I can't, and they're specifically written. So I'm happy to send them to you. If I can do that. Can I get your name again?
That's fine. My name is Anthony.
Anthony, okay.
Email is fine. Let me give you my email in a second. It is Anthony.Richiez.
You cut out on me. You said it's Anthony?
Mm-hmm. Anthony.Richiez, Richiez.
Let me make sure I got that right. Richiez.
Mm-hmm.
All right.
At jud.state.
Got it.
ma.us.
Okay. Okay, I'll have it to you here in just a moment, Anthony. Thank you so much for your help with this. Are you wanting me to stay on the phone? I just sent it, but it'll take about 15, 20 seconds to get out of my inbox.
So I'm a little confused. confused on the accommodations you were trying to seek given the document. So is it access to a file and some sort of issue with the GAL?
There's a list of like 10 accommodations. Did you see those at the bottom?
I'm picking up them. So from what I can add to Massport myself, these accommodations aren't within the listings of things that are applicable of what I can personally apply. If Tanya isn't here, if that's normally the person you're in communication with, I could try to find someone else to speak for you if you'd prefer that. But at least from what I can add on Massport's.
Happy to try to accomplish these, however we need to do that.
Alright, one moment, please.
Good morning. How you doing? My name's Andy. I'm the office manager. How can I help you?
Andy, my name's Jay Shore. I'm a certified Americans with Disabilities Act advocate. I am on a recorded line, and I'm just trying to accomplish accommodations for myself and Miss.
Okay. So some of these accommodations you're asking, it can only be done by a judge. I mean, we in the registry, we don't have the ability to. So for like, first of all, to be a presence by Zoom, that has to be allowed by a judge. So that's all of these things need to be allowed by a judge. We the registry don't have the authority to add for these types of requests. You're also asking for a CART interpreter. This is what a CART interpreter means. Is under my understanding that she's not able. She's deaf. Is that correct? She's deaf and cannot read. Is that what that's my understanding? I mean, I just don't understand some of these requests.
So CART is not just for deafness; it's for communication disabilities, and she does have a communication disability.
Okay, so that's all above. This is all above our information here. We don't have these special requirements to be loaded into our computer. Again, this would have to be addressed at the hearing. There's nothing we could really address here in the registry, sir.
There's no way we can address it at the hearing because 28 CFR 35.107 prescribes.
So you can spit. Sir, I'm not an attorney. We're just a registrar. We take in paperwork, and that's all we're about the paperwork. What you're asking is higher than the registry. These are judicial matters that we cannot just automatically do this. There's a lot of requests that need to be approved, sir. There's a lot of requests that need to go to the judge. So a lot of this stuff needs to be addressed at the hearing, sir. There's really nothing else I can do.
May I have the ability to respond without being interrupted?
Well, I had to finish before I could.
No, you actually interrupted me.
Sir, if this is going to be confrontational, I'll speak.
It's only confrontational because I was interrupted. I'm just letting you know how this works with the ADA.
Sir, okay, I am not very familiar. I understand you're certified with the ADA. I understand that, but do you understand that we here in the registry don't have the abilities or the authority to do some of these requests? This is why I'm asking you to address this with the judge directly or the judge's clerk directly. That being said, if I will forward you to my first assistant registrar, and he can discuss this further. But this is basically a higher than a registry function.
That's why the ADA puts up a court administrator. ADA coordinator.
So I'm going to forward you to someone higher than that, maybe are better equipped to assist you. Please hold.
Yeah, maybe you should, Andy.
Hello.
Hello.
I'm going to transfer to the first assistant register.
Is this Anthony again?
This is Anthony speaking.
Okay, thank you.
Good morning. Suffolk Probate. How can I help you?
Yes, man. I know who I'm speaking with. My name is Jay Shore. I'm a certified Americans with Disabilities Act advocate, and I'm on a recorded line.
Good morning, Mr. Shore. My name is Greg Tarian. So how can I help this morning?
Okay, so I've sent the email to Anthony, and I sent it also to Miss Bruce Pagan, requesting accommodations for Miss in Pierce, and just trying to. I haven't received a response, so I'm trying to figure out if we can accomplish those accommodations today, or if she's going to be unaccommodated.
Let me see. So what is the case number?
SU.
Okay, let me look that up. So that's
Yes, sir.
all right. Let me see. So we have.
Can you please tell me your last name again?
Yes, it's Tarian.
Tarian.
Ayan, as in Nancy.
Thank you.
All right. So I have some filings. Would you like motion for consideration? Some orders. Further orders. All right. Okay. So, so you're representing an individual who is making requests for accommodations, correct? That's my understanding.
I want to be real clear on this, that I am not an attorney, and my role is administrative and is federally protected under the ADA. I'm here aiding and
Yeah. So
encouraging.
what I just asked, I totally understand what you're saying. I just asked, you are advocating on behalf of an individual who is making a request for accommodation.
Correct.
Is that correct?
Yes, sir.
Yeah. So those requests, they have to be done by a motion. And I think that answer was provided to you earlier, and I understand it's not something you're accepting. So I can definitely provide some explanation. We can have a dialogue about it, and hopefully this is going to resolve all issues. So I'll provide some guidance as to how to get this done.
So,
Does that sound good?
yes, sir. May I give my understanding of that?
Absolutely, of course.
So the ADA in CFR 28 CFR 35.160b2 requires that you protect the privacy and independence of the individual, and there's no way to have that protection when you're filing a motion and the other side has access to those requests for accommodation and or can use those against you. So that's not something that can comply with the ADA, is to ask for it in court.
Sure it can. Those motions can be impounded.
Okay. If someone has a communication disability, how do they access the motion deal? Because I do have a communication disability, and I can't act as her attorney. So
yeah, well, it's. I mean, we're not talking about an individual who needs a guardian, right? We're not talking about somebody who has a mental incapacity. We're talking about somebody who has certain conditions that are protected under the federal and state statutes, correct?
So that I don't know whether to say yes to that or no, but the thing is, a communication disability substantially impairs the ability to communicate. So that's something that the motion piece is it seems in conflict with, in my from my seat, and I've been doing this for 7 years. So I'm not saying your court has it wrong. I'm saying it's not what I'm accustomed to dealing with. And
well, let me give you let me give you an overview of who you're speaking to and what am I relative to a judge and what people generally think of court, but how court really works. And maybe we can try to figure out how to get this done for an individual you're advocating for. So when people think of the court system, they think everything under the roof of the courthouse is essentially a monolithic organization known as court. Well, that's really not the case. Court is comprised of multiple agencies, and the judicial department, where actual judges reside, where they work, is just one of those agencies. Whenever you interact with, quote, the court, quote, you interact with the office basically known as civil clerk's office, right? Now, in district court, civil clerk's office have, they function a little bit differently. This is probate and family court, so civil clerk's office really is the registrar's office. So we are what's known as the registry, and the registry essentially is the keeper of records. And you're not allowed to communicate with the court in any other way, meaning you cannot just send a letter to a judge, you cannot send a request to a judge, other than through the registry, which would be us. And the way we do it is it's not like I get off the phone with you and then I go upstairs and I knock on the judge's door and I say, Your Honor, I just got a call and this is what's happening. That would be impermissible. And, that conduct is governed by various rules, regulations. So I'm a clerk and an attorney. So for me to do that, what I just described, would essentially be an ex parte communication. Because now I become an advocate on behalf of you, who are advocating on behalf of a third party. So essentially, I'd be advocating on behalf of an individual you're advocating for. So that's not how it works. Instead, the way we, meaning the registry, pass on requests to the court is only through one means. And the means would be through creation of a record. And that record is created by virtue of a proper filing. So in this case, it would be a motion. So essentially, it's not like I am trying to throw some barriers in order to either, not perform my duties or to hinder or to somehow otherwise prevent an individual you're advocating for from receiving benefits and accommodations that are due to them under the law. It's just that's the way it has to be communicated. Because otherwise the judge would never come to know that there is this need because there is no request before them. Does that make sense, sir?
It does to a great degree. You're talking about not doing ex parte communications. Is that what you're talking about?
Yeah, so in other words, the only way for the judge to know that the person you're advocating for needs these additional accommodations under the federal and state statute would be if that information is brought to the judge's attention.
So
but I can't bring it to the judge's attention because it would constitute an ex parte communication, and the only proper way to bring it to the judge's attention is through a proper filing, and that proper filing would be by way of a motion.
So your canons, Rule 29A1, allow for ex parte when it's administrative, and we just discussed that there are many facets to the court, and the one I'm dealing with is administrative. It has nothing to do with her subject matter or the parts of her case. Only has to do with accommodation. So this is ADA is all administrative. So your canons, your judicial canons, actually allow for ex parte for administrative matters, and this is administrative equal access under the ADA.
I mean, I hear, and I appreciate you have a different view of what we're discussing, but that's where it stands. So the established practice, as supported by the law, is there has to be a filing of a motion. Now, if information presented in the motion, as you said, would negatively affect your, and I'm just going to say your client loosely speaking, so I don't have to say the person you're representing. If the motion would negatively affect substantive portion of your client's case, then we're probably talking about significantly more than just administrative matters, such as scheduling. But if that's the case, there is an avenue of certainly making a request that these motions are impounded. So essentially, there'd be a motion to impound. Motion to impound would describe what is being impounded and for what purpose. There's going to be an affidavit which describes what type of harm the movement is attempting to prevent. And then what's going to happen is that it's going to be brought to the judicial attention immediately. And as the judge considers the motion to impound, the judge would also consider all the other requests. But that's the way these are brought to these are how these matters are brought for judicial consideration.
So, since you're speaking to the law, can you tell me under the law how I, as a third party who is merely aiding and encouraging another in the exercise and enjoyment of their rights under the ADA, how I would file a motion for a client when I'm not a party to the case? I don't have any standing to do that, do I?
I can't make any comments regarding that. I mean, it's, you know, I appreciate the question. The question is poignant, and you're making a point, but it's just not something I can provide. I mean, I may have my personal opinion, but that'd be beyond the scope of this conversation because I am simply trying to provide support within the purview of my office.
Well, there is an ADA coordinator that is supposed to be accessible under CFR. I'm not going to start spouting out a bunch of codes for you.
Yes, that person is Tanya Busta-Pagan.
And
we already know her name.
And so the thing is, it's her job to make sure that the compliance is there. She's not in, and I'm here.
She is in. She's available. Absolutely. Like I said, as soon as the appropriate pleading is filed, that's going to be processed right away. Like I said, if you were to file these requests, including impoundment requests, this morning, all of these matters would be addressed this morning, or as soon as they're filed.
So, I guess what I'm confused about is that the ADA prohibits eligibility criteria, and what I'm hearing is that a motion has to be filed, and I can't file it because I'm not a party. And you're not saying I can't file it, but you're saying that it needs to be filed, and I know that I can't file it because I don't have standing to file in her case. And so I don't. Basically, I've got a bar on accessibility for myself for advocating for my client. So I'm not really sure how to proceed.
Well, are there any other questions I can address this morning?
I don't think so, but I appreciate your time. And
Absolutely.
Thank you so much for talking with me.
Okay, my pleasure. Take care. Bye-bye.
So my upcoming class, starting August the 10th, is filling up. And I've got a few seats left. And honestly, I'm going to give you the whole ball of wax that I do when I do advocacy. So if you want to be a part of it, go to my website, adaRightsTrust.com, and click on the link for the 4-week boot camp. And I would love to see you there.